Is Okay, I'll begin with it. So, Probe is basically a monthly magazine, student-run monthly magazine, and which is published by Caucus, the Discussion and Deliberation Forum of Hindu College. And while Caucus was established in 2007, Probe started its journey in 2007 during the pandemic. And this year, the December issue will mark 3 years of Probe. And this time, we are also fortunate to have an expert article by Major General Anil Verma on electoral bonds. And without further ado, if we could start with the session, and show over to you.
Good evening, sir. Once again, thank you so much for your time. And we could not be more grateful as I've been following for a very long time. So, sort of a fanboy moment for me as well. Nonetheless, we'll begin with the question. So, I'll begin with the first one. You have been at the forefront of the legal domain for quite some time now, being a part of multiple landmark cases. In your practice, how would you describe the evolution of judicial intervention of topics which concern the privacy of the citizen and political contention, like the Aadhaar judgment, where Justice Chandrachud, as he then was, called it a fraud on the Constitution? Further, in your experience on matters of public policy, we would like to know your analysis of influence of said contention in shaping policy.
So I think, Shubh, the first question which you're putting to me is that what is the role of the courts in shaping policy and its practice in the domain of technology? And I think the courts have played a very important role. And in fact, my first interaction with how policy was being formulated around technology in India happened through the courts. So the initial litigations which were concerning how technology is impacting people quite often happened to be around areas of free expression, in which people were discovering social media and then using it to make certain kinds of posts online. And what it was doing was that it was putting into conflict what was a social understanding and practice of speech, in which we say things to each other, but people putting it online also then brings this higher amount of scrutiny of laws such as hate speech, defamation, etc. A lot of them are archaic, they are not well formulated, or their imposition itself is in some ways threatening our constitutional understanding of fundamental rights to freedom of speech and expression. And here I was lucky enough to work as a junior lawyer in the case of Shreya Singhal versus Union of India, which challenged the constitutionality of Section 66A of the Information Technology Act. And that led to the court declaring that because the law itself was very vague and it was then ripe for abuse, in which a person could be jailed or prosecuted under this law for any kind of comment online, they ruled it to be unconstitutional. Okay, so the courts have had a very significant role in shaping technology policy, which also speaks a little poorly to how laws are drafted, or sometimes vacuum in the legal regulation of technology itself is presented, or how technology itself, maybe another takeaway is to think about how technology sometimes aligns with a framework of power that can threaten rights. So I think a lot of these things have come through the courts. The Aadhaar litigation has been one. Litigation on the IT rules much more recently has been another area in which people have talked about it very openly. And much more recently, the seizure of devices, right, of journalists as well as other people, whether it is a proportionate exercise in the interest of fulfilling an investigatory purpose of law enforcement, or is it by itself a roving or fishing expedition or requires safeguards. So I think the courts have a very vital role to play in the enforcement of fundamental rights, as technology quite often has the tendency to align with frameworks of power.
All right, thank you so much, sir. You've touched on a lot of topics we'll be covering in this discussion. But first of all, I would like to mention a certain ruling once again, as you've already mentioned so much about the courts. In Anuradha Bhasan versus Union of India, 2019, the Supreme Court held that the suspension/restriction of internet services should not be done in a disproportionate way, and state-imposed internet restriction must be proportionate to the situation it was trying to control. Now, with that judgment, I would like to ask you two things. How did you perceive the situation in J&K, and how did you perceive it after the judgment came? And second of all, in recent times, how would you interpret the situation in Manipur and the internet shutdown there?
Okay, thank you, Shubh, for asking that question. So, the internet, in fact, all telecommunications were suspended in the state of Jammu and Kashmir after Article 370 was revoked. So, I think that was 5th August. And internet remained suspended there, mobile internet, in the districts where it was last restored for close to about 551 or 52 days. So we should look at it from the perspective of how long there was a period of deprivation of internet access, and mobile-based internet access is the primary method of how people all over India access the internet. Wired-based internet access is usually there for privileged socioeconomic groups, people who use laptops or desktop computers, or people who are in offices or government departments. So most people use internet through mobile, and that remained shut for such a long period of time. And what's important to remember is it was not only shut in Kashmir, which is Srinagar and the adjoining areas, it was also closed in Jammu. So as soon as the internet was shut down, what happens is that quite often there's a very severe impact which occurs socially, economically, culturally, in terms of a person's daily life. And we have to remember that the internet was shut down during the period of the COVID pandemic, where there was, of course, an understandable need for a certain degree of restriction on physical movement to ensure that crowding does not take place and COVID does not spread. So it required people to take remote classes, remote health, or conduct their business over Zoom calls. And a lot of this was not possible in Jammu and Kashmir at that time. So there was a very high degree of deprivation, of injury, which was there. And also internet shutdowns don't distinguish between what are good websites, what are bad websites, and don't reason it specifically. So per se, in many ways, it's disproportionate. Though that matter as to the constitutionality itself of internet shutdowns was not before the court in Anuradha Bhasin. Anuradha Bhasin is the editor of Kashmir Times, and she's faced a high degree of state repression. And she approached the Supreme Court questioning the constitutionality of the enforcement of the internet shutdown. So there are two differences. There's a difference in basically challenging the per se unconstitutionality of internet shutdowns, which is that you can't do it at all. The second is you have enforced an internet shutdown, right? So we are questioning the action, not the principle. So we're not questioning your power to put an internet shutdown. We are saying that you can't do it the way you have done it. Okay. And here, the first argument by the government was, we can't even disclose you the orders of internet shutdowns. They are secretive. And here the court essentially pushed back. It said that transparency is necessary because whenever you interfere with anybody's freedom of speech and expression, you need to set out reasons and you need to make that person aware why their fundamental rights are being restricted. It also gave other safeguards, such as internet shutdowns can't be perpetual. There needs to be an administrative review of internet shutdown orders. But it's also important to remember what the court did not do. The court did not, in fact, get into the orders which were passed by the central government for shutting down the internet. It did not actually see the orders and say that the law which we are laying down, whether it's been followed in those orders or not. It sent it back to the central government and it said that you reassess your orders. So the outcome from the Anuradha Bhasin case was not an immediate restoration of internet shutdowns. In fact, there are about 3 more cases which were filed subsequently, which I was associated with through the Internet Freedom Foundation, in which we were asking for restoration of internet access, not only, again, I'll say in Kashmir, but also in districts of Jammu. All through that period of time, internet shutdowns were mechanically extended all through that place without adequate factual basis to support them, as much as the orders were made public. Sometimes the safeguards were not followed. Sometimes the orders were not uploaded prior to the internet shutdown. 5 orders were uploaded all of a sudden at the end of the month. Okay. So we noticed a lot of things. People from Kashmir, Jammu used to tag IFF on its social media handles. Quite often they used to tag the government. They used to plead with them. And eventually the internet did come to be restored. But I think so it took a lot of international shaming, which resulted in it. So it wasn't only the courts. In fact, I remember there was a tweet by Rihanna of a CNN article of the internet shutdown in Kashmir, which led to some kind of diplomatic incident. But my friends, constitutional lawyers who practice in courts, sometimes like to question whether it was the Supreme Court or a tweet by Rihanna which led to a restoration of internet in Jammu and Kashmir. And if people want to look at the chronology of this litigation and the subsequent cases, there is a journal article which has been co-authored with Devdatta Mukhopadhyay, who was working at Internet Freedom Foundation at that point in time. And I'll provide a link, and possibly people can look at what were the different cases, what was the court looking at over this period of time. But it's important to remember that the court's decision in Anuradha Bhasin did not lead to immediate restoration of internet access.
Thank you so much, sir, for your answer. And as you said about that the case challenged the entire principle of internet shutdown, and delving into it a bit deeper. So at one end, we see that the government is pushing for digital India, and internet has become a necessity to avail various welfare schemes of social protection, right to work, PDS system. And given that as you mentioned, that the shutdowns are usually on mobile internet services and not on fixed line. And
Yes.
this impacts rural population more because majority of them use mobile devices to access the internet. So how
Yes.
do you view the relationship between access to internet and basic rights and the differential impact on various communities?
Thank you, Gauravi. Gauravi, I think there's a disproportionate socioeconomic impact because most internet shutdowns in India are on mobile internet. And quite often you have to think about it from the administrative perspective of it playing into some kind of remote public interest that there may be a tendency for people to use instant messaging or make a video which goes viral and then excites a mob. But it basically brings me to the question that is the state failing to enforce law and order? Is shutting down the internet a good excuse for it? Because, irrespective of, a communal flare-up, most of the people in that area will also suffer a degree of incredible deprivation of from the internet, from doing their regular day-to-day function. So it's possibly like a curfew. I've talked about it much more recently in the context of the internet shutdown. In Manipur, I've written 3 op-eds in which I've questioned the basis of limited internet shutdowns, in which wireline internet access is permitted, wireless is banned, and somehow that's seen as proportionate by arguing it's just not proportionate per se. And the alternative which I offer in terms of if there is an urgent need, exceptional urgent need, it needs to be firstly with procedural safeguards and processes, which means that orders need to be public. They need to have clear reasoning, factual inputs, why not the internet is being shut down, why specific websites are being blocked. And it needs to be disclosed publicly because the public also has a right, fundamental right to know. Okay. And it also needs to be limited to time. Okay. So it can't be a perpetual ban in that sense. I think what we are facing today is that there's a great amount of power which is right now being exercised in terms of the direction technology should take, where the state is saying that, yes, you should use it, but you should only use it in the way we want you to use it in that way. And of course, it also then plays to the political interest of the government, in which when people ask them for transparency, accountability, they don't want it. So it's manifesting in different kinds of issues, from surveillance to freedom of speech and expression. So the conception of digital India is not a form of universal internet access, which is without a political conditionality. It is coming with a prescription that you need to use it in this way, right? We are going to direct you that you need to utilize the access to the internet for the instrumental goals which are setting out by the government, okay? And you can't use it for other things. So, and that itself, I think so, undermines the promise of the internet, which is essentially a medium for curiosity, exploration, for people to do new things, right? Innovation is at the root in terms of a decentralized network in a sense, right? But it's not truly decentralized in a way. But still, the political value behind the internet has always been that you, to a large extent, do have a degree of state control on illegal action, but there's a wider sense of liberty, of freedom people feel when they use a digital device. And I think that's in conflict, that's a friction which is presenting itself in how the internet is being shut down in India more than any other country in the world.
Thank you so much, sir, for your answer. And as you mentioned about the state control and the influence of state on this, I would also like to bring in the judgment about in the Twitter versus Union of India case. And how
Yes,
do
yes.
you view the influence of government in arbitrarily curtailing certain voice that go against them without any written justification or prior notice, and limiting their freedom of speech and expression on social media platforms?
So, just a little background about the case. So, Twitter goes to the Karnataka High Court because it's getting orders over a period of time in which the government is saying block not only these tweets, which we are seeing are illegal, but also entire accounts. Okay. And the orders quite often don't have reasons. Okay. And these orders also match the factual timeline of the farmer protests and have actually resulted in blocks on journalistic platforms like the Caravan. Okay. So the Twitter says, on behalf of our users, we are approaching the Karnataka High Court, representing their fundamental speech, fundamental right to freedom of speech and expression, because these orders are made in secret. Okay, so our users can't approach the court directly. Okay, they're sent to us. We can't disclose it per se to our users because the government is also saying you should not do it. Okay, the orders don't contain reasons in writing, hence they by itself are arbitrary and therefore blocking of entire accounts, which is disproportionate because an account can't be illegal per se, right? You need to have some justification to say there's repeated misconduct or criminality. Otherwise, it'll just be one tweet, which will be withheld through a blocking direction. Now, the Karnataka High Court basically rejects all of this and says the government has adequate power to take these actions. I've written on the judgment actually in the Indian Express and op-ed, and people can possibly read my reasons for disagreeing with the court. And in fact, I find it very surprising that the court avoids deeper constitutional examination on the powers of the central government because, the fundamental right to know and its impact is directly on the individual users of Twitter. That's the first thing, right? So if the fundamental right of freedom of speech and expression is being restricted, the state should ideally inform them, okay, and needs to certainly establish that it is informing them, it is providing them reasons and a legal process, okay. In addition to that, it's not only the users who are impacted, it's also the readers. Social media platforms like Twitter are public forums, and there's a constitutional right for the right to receive information because it's reason that when we read something, when we watch something, we formulate opinion, right? So our opinions, our knowledge comes from the information which we receive, and based on what we receive, we speak, we express, we formulate our opinion, right? So it's really important that for us to have a fundamental right to freedom of speech and expression, that we receive speech as well. So there's a general public right there. So the orders also need to be made public. And here the court itself does not enter into sound constitutional examination. Also on proportionality, it does not actually look at the orders properly. Okay. And in fact, there's a lot of detail which is missing from the court case, and it passes strictures against Twitter. I am no fan of Twitter. I've been on Twitter for close to a decade. I get a lot of abuse on Twitter. I get it under every tweet, okay, for nonsense, okay. And, and I also disagree fundamentally with the surveillance capitalism model in which your data, your behavior on digital platforms is harvested, and then you're shown different kinds of ads which play to a different kind of mental insecurity you have by this, and you'll be more complete as a human being. Okay, I don't like any of this. Okay, so I think in a battle between Twitter and the government, it's us, the ordinary citizen, our freedom of speech, which has lost out in the Karnataka High Court. And one final comment on the Karnataka High Court's decision, I find it so curious that they would cite the statement of the G20 in Sanskrit and some kind of theological reasoning when, it's a constitutional adjudication. It's a very dangerous sign when constitutional cases are being influenced by political messaging, right? So I think that it kind of impairs the impartiality, at least as per me, of the judgment.
All right. Thank you so much. So that was actually very in-depth on a lot of things we generally don't know about. So that is one reason we would love having professionals on the probe. And so now you've spoken about the Karnataka High Court quite a bit. I would like to redirect to the Supreme Court. In 2017, the Honorable Supreme Court asserted a fundamental right to privacy, which has paved way for many memorable judgments. Nonetheless, we would like to know the definition. The definition of privacy in digital sense is still a gray area. We would like to know how you think the law should demarcate what qualifies as protected under digital privacy and what should not be protected. Further, how do you think this relates to the IT Act of 2021?
The IT Act.
Yeah.
So the IT Act was made in the year 2000. There's some rules which are made under.
Sorry,
so
the
I
amendments.
refer to that. I'm
Yeah.
only doing it for the purposes of clarity. Okay. Now, in 2017, in the case Puttoswamy judgment, the Supreme Court reaffirmed that privacy is a fundamental right and links to each fundamental right. Okay, what it did was it said you need privacy to exercise so many choices in your life: wear the kind of clothes you want, eat the kind of food which you want, okay, marry someone, your identity, your sexuality, what you want to read. Okay, so privacy needs to be considered from the lens of a doctrine which preserves your liberty, autonomy, and dignity. And that's the way the court verbalizes it. So it's much broader than what is called as informational privacy, which becomes relevant in the digital context. So it's really important for people in terms of their diet, their clothing attire, their choice to, and of course the state can restrict it, but then the restriction needs to be as per the conditions which are set out in the Puttoswamy judgment. Okay, so that's what's important to first remember. Now let's just deal with informational privacy. Informational privacy has been considered by the court, if you read the different opinions, as a representative of power. Okay, so we are quite often told that the more somebody knows about you, the more power they have, and quite often, metaphorically, it's been explained through the architecture of what is called as a panopticon. Okay, which is a central guard tower in which you can't see the guard, but the guard sees you all the time. And if you remember, when Jeremy Bentham drew out the panopticon and wrote about it, you know what was it meant for? It was meant for the welfare of society, because he said that the panopticon essentially keeps people who are criminals or those who can't take care of themselves, people who may be suffering bouts of mental challenges, physical challenges. So somebody needs to see them all the time. So let's take care of them by surveillance. But what it does is that it builds a system of power, right? And we know that from our parental relationships or from a friend who was always imposing their choice whenever you go out to eat. Okay, you feel it, right? They know you, and that's why they say, you will like that. Okay, they presume that. Okay, so it takes away your ability to exercise choice and autonomy the more people know about you. Now, in the digital domain, because we are connected by devices which have a bundle of sensors which are always gathering information on minute movements or also the absence of movement or other metrics of data, they get a very deep insight into our behavior as individuals. And on the basis of that, they have an immense hold of power. That's essentially a system of a surveillance-based society in which either they may be able to reap it for profit or may be able to reap it for power, political power in a sense, right? Contour us, okay, direct us towards certain things. And here the court says that it needs to be limited by what is called as a lawful purpose. It needs to be tied in what the constitution says the state should do. Of course, the state should keep us safe, but the state should not in a way keep us safe by keeping us in a perpetual lockdown, or the state should not regard us as different communities who need to attack each other. That won't be a lawful purpose, will it, right? Second, it needs to be in a way which is done, which is necessary, okay? So the information collection needs to be tied to the purpose. So if you can do the thing without getting to know or surveil me or ask me for a whole bundle of data, you should go ahead and do it, because why create that massive apparatus, right? It doesn't make sense, right? There's a likelihood it will be abused. That's called data minimization, right? So, and then the data which you collect will also be tied to the purpose. So you won't ask for extra details, right? If you're just wanting to know when I'm entering a building, my name and my phone number, why should you also ask for my biometrics? Why should you also ask 20 different other things, right? So that's extra personal information which won't be gathered. So it needs to be proportional, right? And then it needs to have adequate safeguard. All of this needs to have a legal basis, which means the government should make a law for it, okay? Which then makes sure that these things are actually set in stone. Now, Shubh, what's happened, unfortunately, has been since 2017, we have not seen adequate enforcement of the principles in practice, either in cases or in terms of the union executive itself implementing them or state governments implementing them. I come from Delhi, right? Now you have the CCTV cameras which are being installed everywhere on roads and classrooms. There's no law. Forget necessity or having deeper arguments. There's no legal basis to them being installed. So it's ripe for abuse. Similarly, facial recognition projects which are being launched. Similarly, electronic databases which are being built, etc., etc., etc. And quite often there's a social attitude which is emerging that, well, everyone has our personal data. What difference does it make? The difference which it is causing over a period of time is that we are becoming a much more surveyed society. We're becoming a much more scared society, a fearful society. We're censoring our own actions. And it's not happening immediately. It's happening as a gradual shift over a period of time. So you're always watchful what you say, where you say, right? And that's a problem, according to me. That's not an open society.
Right. Thank you so much. So actually, I very much resonate with your feelings. And as a sociology student, I loved your references to all the scholarly work as well. Nonetheless, you mentioned about the legislative vacuum in just now. So I would like to ask you, in contemporary times, facial recognition and fingerprint recognition technologies are glorified, as you've already seen. But many still do not know how they're actually utilized by said actors. As an expert in the field, can you divulge how the said technologies are used and misused in India? Additionally, can you also elaborate on the institutional safeguards, if any, that are present regarding the same?
So thank you so much for asking that question. I'd just like to caveat by saying I'm not an expert on technology. I'm an expert on the legal and policy examination of technology in terms of social impact. From what I've been seeing around facial recognition technologies has been that it's not being used for one thing. It's being used for different things: state security, identification, etc., etc. Now, it's not as if the technology is accurate right now, right? Of course, it is getting accurate as it trains on more data. But right now, the technology is nowhere near 100% accuracy. So it results in exclusion. That's the first thing to consider, right? So quite often people say, what's the harm, right? But if you tie it with a very critical function, like payment of somebody's wages, rations, or somebody being able to cast a vote in an election, it can have a dramatic impact, right? It can lead to somebody not being able to access something which is guaranteed to them, which is the very basis of why this country was created and we threw out the British, okay? The second thing is that as these technologies also become much more accurate, they're used not for one purpose, but multiple purposes, where the same camera is used not for only identification of a person who commits a crime, but watching everybody who passes through that. And when you integrate that with a large enough database and you have everyone's face on it, you can track everyone's movement over a period of time. And then you can impose systems of behavioral change. Of course, it will make a lot of people really happy who say that, oh, there's too much littering in our cities, or people don't have traffic sense, etc. But imagine a society which is based on fear and coercion, and that is China, where they have a social credit score system in which if you do something undesirable, you're not allowed to do certain things. Now, there may be some people who may say, let's take the China, Singapore path, okay? But I'm not those people. So we disagree in principle if you are that person. But for the people who believe that in a democratic framework, you do need to have penalties, but you need to enforce them in a way where there are adequate safeguards and you can't have these large systems of surveillance, I would like to get into that a little much more. Now, what's happened quite often, Shobh, is that there's a project we built on the Internet Freedom Foundation, which is called Panoptic, which actually comes from the Panopticon, and it's called panoptic.in. If you go to it, you will discover that there are about 70, about 90, 120 projects. There are thousands of crores which are being spent, but there's not one law There's no legislative basis for ensuring that the facial recognition systems which are now implemented have audits, have security systems in place to ensure that the data does not leak. But most importantly, the use for which the facial recognition technology is used and deployed remains that. So somebody who is implementing facial recognition technology, let's say for beneficiary welfare entitlements, rations, does not get to use that same data for law enforcement purposes. Of course, it's more efficient. It's a data creep in that sense, but it's also illegal. You need to go ahead and pass another law, and it needs to stand the test of constitutionality. So, quite often what we have noticed is that through executive action, through notifications, these kind of things have happened. And the courts, unfortunately, despite pending legal challenges, have not yet been able to deliver judgments as to a declaration of the illegality.
So in the recent years, India has come under attack of some high-profile data breaches, such as the Coven platform breach or the Employees Provident Fund Organization breach in August 2022, and the ransomware attack on AIMS in November 2022. So in this regard, can a robust national cybersecurity strategy help plugging these breaches?
Gaurav, thank you so much for asking me that question. So data breaches are essentially our gateway to impersonation, financial fraud, and making our entire goals of digitization very, very suspect, because it puts into a person's hand the data of possibly thousands or millions of people, and that kind of personal data then is used over a period of time, not only to profile or surveil a person, but to impersonate them, try to siphon off their bank accounts. And quite often it's done on people who either lack digital literacy, or even people who are very sophisticated with digital literacy. So what if you are getting a call from somebody who knows your Aadhaar number, your driver's license number, when you last insured it, and says they are calling from a bank, and then also give you the details of your last bank statement? You are very likely to talk to them for 2 or 3 minutes. Now imagine that's your grandparent. Now these are the kind of issues which are manifesting themselves regularly, because the entity which looks after data breaches by public departments, which is called the Computer Emergency Response Team, I don't think so has the adequate funding, skills, and expertise to account for the scale of challenge which is happening. Now, India is making a very ambitious government to citizen digitization transformation, and also that's being reflected by the private and the larger public sector. You may have heard things about the digital public goods, etc. But at the root of all of that are leaky databases, because they're gathering more information, and the security itself, I admit, it's tough to implement. It's an evolving threat landscape, but I don't think so it's being done properly. There's enough resources which are being deployed towards it, much more particularly towards how much data should be gathered, okay? And how should we also think about, let's say, architecture of these services. If you're linking everything to one Aadhaar number, okay, there's a larger likelihood that people will be able to connect two leaked databases and put them together, and thereby have more information on an eventual victim. I don't think so enough thinking is going into a lot of this, or enough thought. It's being thought about something like inconvenient, we shouldn't deal with it. So data breaches are happening. What you're also noticing is that data breaches are happening repetitively. So if you look at the railways, okay, it's had data breaches in 2020, 2021, and 2022. Why is it happening, right? You need to ask these questions. So I think it's a mix of incompetence and people in the public sector not wanting to own up accountability. And here, I think so national cybersecurity policy will help. The last one was made in 2013, and one has not been made since then. Some countries make one every year.
The next question, as we were talking about personal data, so is regarding the recently passed Digital Personal Data Protection Bill in the monsoon session. So the legislation makes it mandatory for companies collecting user data to obtain explicit user consent before processing it. However, it includes certain legitimate uses as an exemption for data collection, without user consent, and also to a certain extent exempts the government on many matters. As someone who has been an expert in this field for a long time, so can you elucidate on the implications of the bill and its relationship with the right to privacy?
So, the Digital Data Protection Bill should be considered as a law which has been made not to protect individual citizens, but to protect the state in its data collection practices. So, it's essentially a act of parliament which is increasing power of the central government to determine how the law actually will be implemented, because the law in various portions provides the central government with complete flexibility to whom it will apply and how it will apply. The basis of this statement actually comes from not only the exemptions which are within the law. For instance, the law, without any clear criteria, provides the central government the power to exempt not a group of companies, but one single company or one single government department. So I find it very peculiar. And the exemption is for the entity, which means the company or the department, rather than a specific purpose. Okay, which means that if you're doing that activity and you're this government department, the activity is not exempted. The entire department or the entire company is exempted. And what it does at the same point in time is that the implementation of the law to a large extent does not occur through a regulatory body, which means that if you look at data protection laws in different countries, there needs to be a government body which is established to develop a regulatory framework in which it not only enforces the law, in which it investigates whether the law is being applied or not, okay, but it also then issues practice guidances. For instance, there is a MSME unit, micro, small, medium enterprise unit, okay, which is engaged in, let's say, industrial manufacture, for which it keeps payroll of about 300 to 400 people. How should it manage that data? Okay, so that kind of advice comes through what is called as a data protection office, agency, authority, etc. in foreign countries. We have not established that. We've established a data protection board to which complaints are sent and which then adjudicates and decides them. And this is completely picked by the government. So the standards and the application and its determination is still left to the central government, which means the Ministry of Electronics and Information Technology, which also wants to improve investment, which is promoting the private sector. And yet at the same time, it will apply the law on the same people. So for instance, if you go to the Twitter timeline of the Minister of State, Mr. Rajesh Chandrasekhar, only 3 days ago, he's meeting the public policy head from Meta Platforms, Joel Kaplan. Okay, and quite ordinarily, this law will apply there. And it brings a good faith query on fairness, conflict of interest, in which the political interest as well as the governance interest may intersect. And what I mean by that is, if the minister himself is determining how the data protection law will apply to companies without any regulatory body, which will be independent, then this kind of apprehension will be there even in the mind of the people who will support and ideologically be aligned with the government of the day. So it's a design fault. That's what I'm trying to say. And it's a peculiar data protection law, Gauravi, because I think it's the only data protection law in the world, and I say this with seriousness, which imposes duty on us with the threat of penalty, like you and me, who do not collect data, who give data. It says you have to give complete and accurate data to any data fiduciary, and if you give incorrect data, there will be 20,000 rupee fine. Okay. It also says that you need to give your complete ID, etc. And quite often, I know my female friends don't give complete data or their government data to a lot of people because it may be used to stop them, like, or just cause an unpleasant encounter, right? It's a safety method. Okay, it's not like somebody's lying just because they want to evade their taxes or things like that. Okay, so it's done for personal safety reasons. It's a choice, right? And it also says if you file false complaint with the data protection board, which is that if you complain and it's found to be false, you will get a fine again. Now, here's the thing. A lot of sophisticated methods, technical methods cannot be established to the certainty of evidence sometimes that there has been a data breach, that they have collected more data than they promised they would. Okay, you can complain, you may have an apprehension, right? And you may be wrong. So why should there be a fine? It's going to discourage people from seeking enforcement of the law. So in any way, I think it's not looking towards enforcement in terms of bringing in what the minister likes to call guardrails for the internet or for the digital world. I don't think so. It places any kind of guardrails for there. I think it's actually pouring water on a bathroom floor.
Thank you so much, sir, for that. And while we're talking about legislative provisions, I would also like to ask your thoughts on another bill that has recently been introduced. The Ministry for Information and Broadcasting has recently introduced the Broadcasting Services Regulation Bill 2023.
Yeah.
The extent of the bill's reach is extortionately wide and also concerns citizens who are sharing information as well as misinformation on social media and other channels. We would like to know your interpretation of the bill, how it can impact the framing of future mainstream discourse, and its effect on those who are not intricately aware of its provisions.
So, Shubh, the broadcasting regulation bill has been released recently for public consultation. And I think people can send in comments till about 8th or 10th of this month to the Ministry of Information and Broadcasting. What it aims to do, as per the statement of the Cabinet Minister for Information Broadcasting, Mr. Anurag Thakur, is to modernize the regulatory framework, because the previous law was actually focused towards cable television regulation, which is called the Cable Television Regulations Act of 1995. It was first made as an ordinance. And here with the primary method for both entertainment as well as news and current affairs being either an internet-based media ecology, they're shared, either of them are shared through the internet. It's essentially reasoned by the government that this is why this law is necessary. Now, based on this, a lot of people will say, yeah, what's the problem? The law should be there. So let's look at what the law is. I think the government basically is increasing its control over individual YouTube creators, okay, not only OTT television channels, and it's also bringing in a censorship system. And it's doing it all under very vaguely framed proposals. In fact, it's saying that every time Netflix or Amazon Prime or Jio, they need to make a show, an OTT series, there needs to be a content evaluation committee, and the name of the members of that committee need to be made public, who basically give the go-ahead for the show to be there and for you to watch it. And the problem in a country like India is that not only do people disagree with each other, sometimes they disagree violently. Okay, something or the other ends up offending someone or the other. And this is why the internet is a great thing. You can like switch a tab, okay? Or you can like watch the 10,000 is a low number, titles on Netflix. It may seem like, oh, there are no 10,000 movies, but they're actually like 50, 60,000, which will be available at a point in time. So, you can shift from one to the other very easily. So there's also a very different kind of medium. You don't have about 200 static channels in which the programming is determined for you, right? So you have that ability of choice to move away from, your discomfort, your offense towards something you want to watch. And here, I think the government is bringing a huge amount of control by saying that, oh, implement the censorship system and we can also do this. Okay. And again, it's not setting up a independent regulatory authority, which is called the Broadcasting Advisory Council. In fact, all the decisions will make again at the ministerial level, because they will receive the advice ultimately and then decide what to do. Okay. So essentially what's happening is that we are going to see Doordarshan type programming over a period of time on OTT channels, which means that what are good Indian values will be shown, okay? Things which basically parents can sit with their children and watch together, which is great. But sometimes parents and children also want to watch shows separately on their smartphones, right? I know for a fact my parents love Narcos. Now, under the program code, if you don't allow obscene language, okay, people don't watch it. I know for a fact that one of the top shows in India is Mirzapur, right? So there's a sense of hypocrisy also in our society, right? Between what we want to watch, okay, and what we think others should watch. And I think the government is weaponizing that a little bit. The second thing which really concerns me was the regulation on news anchors who have shifted from mainstream news channels towards forming their own YouTube channels, right? Now, the government is bringing this program code again on these independent YouTubers, like people like Ravish, who have massive followings now, right? And the entire reason they had to leave a television channel is because they stated they had a sense of censorship, which is due to the corporate ownership of media and the control of the corporate ownership by the government. Okay. So essentially, my argument also is that, hey, if this self-censorship system is so great, right? How has it worked? Because you're copying the same model which is there for the television to the internet. So just open the television, and I mean, not your OTT app, switch to a television news channel debate. And even if you like what they are saying in terms of the content, you are a great fan of the Prime Minister and the Bharatiya Janata Party, it's six men usually yelling at each other, okay, talking over each other. Okay, your heart rate is bumping up. Okay, in that sense, it's a show, it's a theatrical representation, and themes quite often are partisan. They're either the defense of the government that, wow, we are in such a great space and time because of the political leadership in this day and age, or it is tropes which attack minorities, right? Now, of course, you may love that, but that's all that's happening. So there's no media diversity in a sense, which is left any longer. Which is why I think this regulation is essentially going to, again, lead to the kind of content you see on television. And if you're not happy with what you saw on television, which is why you purchased that smart TV this Diwali, and you stream your OTT shows, you should think that, well, same television content is going to be there on your OTT app again, because it's the same regulatory system which is coming in.
Right. Thank you so much, sir. As someone who bought a TV recently, this really does strike a chord. Nonetheless, you mentioned about journalists and their voices. So one thing I would like to talk about censorship is censorship of them. There has been widespread criticism of the government's power to curtail dissenting voices through legislative provisions. Now, those are a separate thing altogether. With that in mind, how would you interpret the seizures of journalists' media devices like phones and laptops, which we have seen recently? And do you think the ambit of protection of digital media should be enlarged to inculcate them? If so, why?
So, constitutionally, it's always been recognized that freedom of press is a component of the freedom of speech and expression, and it comes through a whole bunch of cases which are called the press cases, okay? In which what we saw was earlier when governments were not fond of a specific newspaper, they used to essentially challenge their building permit, okay? And try to get the office sealed, or try to say that you don't have this fire license, etc., things like that, okay? So it's done indirectly because the government can't really directly say that what you're writing we don't like, okay? That also happens, but this is done at a much more systemic scale over a period of time. What you are noticing today is that the direct threats which are being made against journalists, just if you look at the number of journalists which are killed on a yearly basis, the number of cases which are filed, the contraction of economic opportunity, okay? Like people need money to live, right? And it's a tough media atmosphere when you don't have that level of opportunity to write and publish what you want. And ultimately also environment of threat, where not only laws which are essentially contained in the Indian Penal Code, but special laws in which there are allegations today of money laundering or people being associated with anti-national activities, potentially unlawful activities, okay, which are security-based laws. So it's a terrible, terrible situation. A lot of this leads to criminal investigations, and quite often the digital devices of journalists are seized. And it's done in a way in which safeguards are not followed. For instance, if a digital device is seized, first thing which should be done, which is also in the interest of the investigator, is to ensure that electronic hash value is created, that the data which we have gathered will not be tampered at a later point in time. That this is the state of all the data on this hard disk. Okay, we've generated on the basis of a cryptographic technology that even if one file is deleted or added or renamed, the hash value changes. And we provide this hash value to the person we are investigating. So we can agree that this evidence which we have gathered is actually the evidence which will be presented in court at a later point in time if the prosecution goes towards a trial. Okay. Unfortunately, none of this has been done. Okay. And also, the seizure of complete devices, one needs to remember, is not like the seizure of a file, a physical folder. Our phones, our smartphones are repositories and extensions of our own personality. They reveal all our relationships over a period of time. They have just the way, if you go through and scroll through anybody's photo album, that's the most intimate picture of their life somehow. If you just scroll through it one after the other, tap. Okay. And what it does is it causes not only a degree of threat to their sources, to that person, it results in a huge amount of mental and psychological trauma, which is why I also think a lot of young people will be dissuaded from picking up journalism as a profession. They may say it's just not worth it. Okay. I think this is why we need a greater degree of safeguards towards criminal investigation, especially towards device seizures and electronic evidence. I've written about this in the Hindu as well. I keep saying I've written about this, because I like to, present analysis around these issues in national newspapers. That's my primary mode of also unbundling these things in my own head. What should be the direction law and technology should take?
And thank you so much, sir. Your articles have also been a prime source for our information. And now my last question to you would be that recently in the monsoon session, we had Bharatiya series bill introduced. So in your opinion, if passed, how can Bharatiya Nyaya Sanhita or the Bharatiya Nagrik Suraksha Sanhita influence the cyber world and data privacy alongside penalties for violations? And what can be the role of the Indian Computer Emergency Response Team in the same?
So I've already commented on the Computer Emergency Response Team, so I won't speak more on that. But just in terms of these three bills, I've not looked at them deeply, so I won't be able to comment on what's the digital evidence provisions, etc., things like that. I think the Project 39A, which is sent at National Law University, Delhi, has done a great analysis, and I'll request readers to look at it. One thing I did look is that there's some amount of plagiarism. For instance, even offenses which we think were colonial, for instance, criminal defamation, which is essentially at its root, or sedition. They have been brought in with different words, but it's the same offense in some way or the other. And, it kind of puts into question a lot of things. It puts into question for me that, okay, you are remaking the criminal laws of this country. And why can't you make it constitutionally consistent? And why can't you actually adopt practices which have been adopted globally? For instance, criminal defamation has been repealed globally in a lot of colonial countries after they gained independence. Why are we still here? In fact, the country which had criminal defamation repealed it in 1996, which gave us United Kingdom. So I think it's a weird kind of colonial mindset which has not gone away irrespective of us gaining independence, and makes me fairly sad.
Okay, sir. Shubh, do you have any other question?
Yeah, I think there's just one last left. So this is more towards the future, as you've already mentioned. There have been many criticisms levied upon the current regime on matters pertaining to censorship, which you have written and spoken about extensively, as you've already said. In the run-up to the elections, we would like to know what impact you think the said censorship can or would have, And how do you think the same can be overcome? Do you think the legal mechanisms can play a role in the same?
So, as much as I think there is a role for the courts, for institutional frameworks to act through, there's been a immense centralization of with institutions have become partisan in the application of the constitutional principle, which means that if you stand on the side of power, then the rule of law all of a sudden will safeguard you. But if you challenge it, if a dissenting voice who's most deserving of the rights, lack in socioeconomic power, you're challenging, you don't have that. So I think what's required alongside institutions acting and growing a spine is for people not to lose hope. I think it's really important for people who believe in constitutional values to talk about them, to have programs like this, okay, to read books. And I'd like to mention, some thinking which is shared by this philosopher called Hannah Arendt, who's written on totalitarianism. And forgive me for repeating how she's phrased it, because I think she uses men as a denominative of a human being. But she says that if you read her book, Men in Dark Times, which is essentially about people who fought fascism, it was about the personal relationships they had with their other friends. And if you then read her book about totalitarianism, you will, especially in volume 3, what you'll realize is that she says that loneliness is the essential condition in which authoritarianism can rise. And you will say, why? What's the link, Apar? Person being lonely and all of a sudden a political system of repression arising? Yes, because, communities which are formed and are necessary need to be reshaped, in which the state can control everyone. So everyone should feel alone, should feel threatened. Okay. And the only sense of community and bond that they have is not even with their families, with their friends, with people from other communities. It is with the state. So what's important is for people to form book clubs, discussion avenues, spaces and venues like this, in which even if you may disagree with Apar and say, oh, he's a critic of the government, or he's partisan, etc., he's a blinkered lefty or something like that. Okay. Even then, a diverse forum like this, in which you possibly can invite a person who can basically provide you very different answers on all the questions you've posed me, is important. So I would say that my takeaway is that irrespective of the results of the next general elections, there's a centralization of power. This culture is not going to go away immediately. And it's a duty, especially for older people, to encourage younger people, and for younger people to have fun and to create forums of discussion which can be diverse, exploratory. It's very, very important in times like today.
Thank you so much, sir, for your valuable time. And our society was entirely based upon this, what you mentioned about the need for discussion rather than debate. So we hope we continue with this. And thank you so much, sir, for your time. And we are sure that your insights would be very helpful for our readers.
Thank you so much for having me.